A society to have order and to protect its citizens must have rules. Rules or laws are created and agencies are formed to enforce the rules. In the United States, you are innocent until proven guilty. Our judicial system, our courts, have the task of determining guilt. When guilt is found, the courts mete out the consequences. If we follow the rules of our society, we may never have to face the bar of justice inside a criminal courtroom. Join us now as we see an actual Lake County court in session.
All rise. Lake County Court is now in session. The Honorable Judge Donna F. Miller presiding. Please be seated. Court will come to order.
All right. Good morning, everyone. I'm Judge Miller. Could all of you, including visitors, please raise your right hands? Do each of you raise your right hand, please? Other right hand. Do each of you swear or affirm to tell the truth, the whole truth, and nothing but the truth, and this you do under the pains and penalty of perjury? Okay, thank you. Put your hands down. Each of you has a right to remain silent. Anything you say can and will be used against you. When you get to the microphone, I need to know if you're under 18. I need to know if you're not a citizen of the United States, because pleading today could affect your immigration status. I need to know if you're on probation or parole, because pleading today could affect your probation or parole status. If you plead today, you're giving up your right to have a trial and to have an attorney represent you at that trial. If I sentence you today on a criminal case, you have to go down to room 105 and either pay the mandatory costs or sign up for the payment plan. Today, we're being videotaped and tape recorded. Okay, this is in custody. Mr. Reams. Okay, Mr. Reams. In front of me, you have no motor vehicle registration, no proof of insurance, running a stop sign, failure to yield, violation of a traffic control device, and failure to stop at a steady red. Mr. Sandor, he was charged in felony court with fleeing and attempting to elude.
Yes, Your Honor.
Sounds like all of these are redundant.
It's all from the same incident.
So why aren't all of these in felony court with the fleeing?
Again, Your Honor, when the officers write a police report, if they use two separate agency case numbers, if on the second agency case number there are no felonies, and on the first one there is, that first agency case number goes to felony court. The second agency case number would be the criminal traffic, which stays in our county.
Are you going to upman these?
No, Your Honor.
Well, it would be my preference if they went to felony court, because by pleading to any of this, it could interfere with what happens up there. Do you have an attorney in your felony case? Public defender or private attorney?
Public defender over here, private attorney in Orange County.
You're welcome to plead to all of these traffic cases and the misdemeanor no motor vehicle registration. But I'm suggesting that entering a plea, you're going to say not guilty, and I'll appoint the PD on all of these. All right, you're present and PD appointed. Okay, so they can work out a package deal up there. Can I have Sarah Hill to the microphone, please? Good morning, Ms. Hill. Were you able to pay off the check?
I paid the check back in February.
Miss Lisa, did you get to talk to her? Yes, ma'am. What are we doing?
At this time, the state would adjudicate on this case. She does have a prior.
And just mandatories?
Well, she still needs to pay the $30 check diversion fee to the state attorney's office, but she has provided proof that she's paid Publix.
Was her prior during the same period of time?
It was prior to this one. It was about at the same time. It was from her adjudication on that case was in February of this year.
And it was in February, and then she wrote another check after that?
No, ma'am. They were both wrote together.
Okay. That's what I'm trying to get to the bottom of.
Or not, well, they were different times, but I thought they were both in Marion County. And I tried to take care of both of them in Marion County. I didn't know one of them was Lake County. But they were both paid, both checks were paid back in February 17th.
You paid Publix back?
Yes, in February 17th of this year.
Show me. Mr. Attardo, could I see that, please? Thank you. Shows everything was done.
Right, Your Honor, she was rescheduled back in February for a new court date and then failed to appear in March.
That was, was when I had moved, I had just moved, or was in the process of moving, so I hadn't gotten anything about a court date.
February was the court date. It was already resent to a forwarding address. So she didn't get our notice, so we rescheduled it. I don't know if she got our notice that time, but we issued another capias for $2,000. So it wasn't that she came to court and we said, if you do this. And the state filed the charge in January, so it got paid off after the charge was filed.
Correct, Your Honor.
So then she should have gone to your office or go to the check diversion fund in Marion County or whatever to have it be non-criminal. So they did happen at the same time.
Yes.
And what happened to your account? You
It's
closed?
I closed it, yes.
Back then, why did these two checks bounce?
Insufficient funds. I had deposited a check that didn't clear, and so it was insufficient funds.
And they both happened about the same time?
Yes.
Could you make a copy of this for me, please? And I need Ms. Hill's other worthless check case. It won't, it may not be down here, but I need it.
It's from
Marion County.
Your Honor.
It's from Marion County.
Yes. That's why I thought they were both Marion County. I didn't realize that one was Lake County. But then my address, I had, at that period, I was waiting on my SSA to start, so I was kind of like floating from place to place and didn't really have an address. And then the address that I did have on the checks, of course, was no good. But I didn't have a forwarding address, so I wasn't getting any mail.
And what happened with the Marion County case? Did they drop it or they?
I went to court and I had a fine to pay, and as long as it was paid and I had the receipts for the checks,
You had to pay a
then it
fine
didn't have
and they
to go.
didn't drop it.
Well, okay, I didn't even go in front of the judge there. I talked to somebody at the side. She set me up. I went and paid so much money by a certain date, and which was actually the checks. I just had to take the receipt for the check.
All right, so in this case, the state wants $30 for the check diversion fund and the mandatory costs. And the mandatory costs are $273 if you pay them right away, or you can do the payment plan.
I would have to do the payment plan because, like I said, I get SSI,
Okay, if you
and I
can
just
plead
moved
today-
in. I just moved into a place.
If you can plead today, it's criminal. So if you want to say not guilty and talk to an attorney saying you didn't know this was going on, you didn't get the notice, you can talk to an attorney. Public defender's $250. If you enter a plea today, I would withhold a finding of guilt and you would just have to pay the mandatories, and included in the mandatories is an extra $30 to the state attorney's office.
Okay.
You're going to do that one?
Yes.
Okay, so you're present. You waive getting an attorney. You enter a no contest plea. I withhold a finding of guilt. It is just mandatories. Add $30 to check diversion fund.
And Your Honor, the state would request that that be assessed as a lien if she fails to pay that within.
I'm adding it to the mandatory cost.
Okay, thank you, Your Honor.
Add $30 for check diversion fund to mandatories. So if she doesn't make her payments, her license gets suspended. So that's how it will be. So you need to go to room 105 when you get your paperwork and sign up for the payment plan.
Okay,
You're
thank you.
going to add $55 to the total that you owe, so it will be larger than you expect when you first, little sticker shock when you see the total. Nina Dundor, please, to the microphone. Good morning, Ms. Dundor. You are charged with driving while license suspended. We continued it for September 5th for you to fix your license, did you?
I haven't had a chance to fix it. I did turn my tag in. It's just been hard. It's been 2 months. I work by myself. I take care of myself, and I just didn't have the money. I do have a printout of everything I need, and it's going to cost me almost $600 because of tickets.
Okay, you have a Polk County ticket that you have to pay, but it's only one ticket.
There's a Lake County one as well.
No, I don't see a Lake County one. Oh, that's an old printout. May I have her Lake County ticket if we have it? Nina Dundor? Okay, got it. For not wearing a seatbelt?
Yeah, there's 2 of those. I have a printout. I went to the DMV yesterday, and I also have
Can I
$150
see-
I have to pay.
Can I see your printout? You had a seatbelt ticket in Polk County 3 years ago.
I have this paper, too, that shows the 2 tickets.
Okay, could I see that,
I'm
please?
sorry.
That's the old Polk County ticket, I think. Ticket 1369. Okay, 1369 from Polk isn't paid. And then you're not suspended yet on the seatbelt ticket from Lake. At least you weren't when they did this printout. Okay, so you have the seatbelt ticket from Lake, and then you have a ticket from Polk, and then your insurance lapsed. Whoa. All right, could you hand this back to her? If you enter a if you get 3 driving while license suspendeds in a 5-year period, Tallahassee will take your license for 5 years.
Okay.
If you enter a no contest plea today, I would find you guilty. Your fine is $200, I think. Let me see if it's $250.
No, Your Honor, it is 200.
Okay, your fine would be $200 or proof of valid DL. So I would rather you spend that money to fix your driver's license. So if you get your driver's license fixed by May 7th, that's 6 months, you have 6 months to fix it,
Okay.
then you don't have to pay the $200, just bring us proof of a valid license.
Okay.
But if it gets to be May 7th and you haven't fixed it, you have to pay that $200 or go to jail.
Do I have another court date, or do I just have to show the...
No new court date.
Okay.
Miss Angie, I'm not sure whether to write it down here or up here. It will be... Okay, Mr. Sander, 29 days suspended?
Yes, Your Honor, and no new crimes for the defendant's knowledge.
Thank you. 29 days suspended upon completing by May 7th, 2013. And no new law violation, no new crimes between now and the next 6 months. If you get a driving while license suspended, or a drug charge, or theft charge, or any criminal act between now and then, you'll go to jail. All right, I think we got it. She needs to be printed. Thank you very much. Jonathan Dickens, please, to the microphone. Okay, Mr. Dickens, you are charged with driving while license suspended. This would be your 4th within a 10-year period. How come you haven't been habitualized yet?
Your Honor, he has an open driving while license suspended with the PD currently.
All right, so I guess we better put this one with the PD also. Are we revoking his bond?
I don't believe he had a bond on the first one, or There's been recent case law showing that if it is a summons, that we can't revoke his ROR status on that, or a citation because they are not provided with the same additional information.
That's not recent, that's from 2007, and I don't agree with that analysis. It wasn't the Supreme Court that did it. I think it was the Parker case you're talking about.
I'm not sure it's...
Well, I have a copy of it, but if you're not going to, you're not going to.
He'll be in court tomorrow, Your Honor. For sentencing on the other one.
All right, so I'll appoint the PD on this one, and we'll see you tomorrow on all of it. Chances are you should bring your toothbrush, as I'm sure you suspect, because enough's enough. So we'll appoint the public defender, PD, and not guilty. And could you make sure we have this one in court tomorrow? Right, wait for your paperwork, and then we'll see you tomorrow. Now, Mr. Dessa. Dessa, I'm sorry. I remember now. Okay. Mr. Dessa, as I remember now, probation called me about your case, and they thought if I gave you a little more time, you can finish everything you need to do with the Department of Motor Vehicles to get your license back. We decided I do not need to keep you on any kind of supervision, so we're going to terminate your probation, and we're going to write on, Miss Angie's going to use her magic wording to say that your that's between you and the Department of Motor Vehicles, whether you get your license or don't get it, or it's suspended or not suspended. I'm out of the loop. You're off probation. You're done with us.
And I just have to complete their requirements for my license.
And their requirements are you have to finish treatment.
Yeah, I have paper. I'm signed up already.
Okay, but probation is terminated. Okay?
Yes, ma'am.
All right, wait for your paperwork.
Thank you.
Daniel Chidester. Mr. Chidester, you are charged with driving while license suspended. Are you still on pretrial intervention?
No.
Your Honor, that was revoked, and he has the public defender handling the revocation case.
Do you want the public defender to handle this also? All right, you're present. PD appointed, not guilty, and we will see you. Is that tomorrow also?
That I do not know.
Do you know if you're supposed to come tomorrow?
Yes, 1 o'clock.
Then we'll have this file back here tomorrow. Wait for your paperwork. Braden Perry. Mr. Perry, thank you for dressing so respectfully for the court. Were you arrested on the KPS for failing to appear?
No, ma'am.
All right, I'm going to withdraw the KPS because you could have been picked up. You were supposed to be here last month, so I issued a KPS for $2,000, but you're here. Dressed respectfully, I'm withdrawing the KPS. And now let's see what we're going to do with the new charge. It's possession of paraphernalia. Do you have a list of what kind of paraphernalia we're talking about? It says for a meth lab, but I don't have a list of any kind.
Your Honor, I do not either. I'm looking it up. I, to be honest, copied and pasted Ms. Mahaney's offer onto the docket for today, so I'm looking it up as well.
I don't see him on the list.
He's on the bottom of page 11 in my own handwriting.
Hey, Mr. Perry, if you want to enter a no contest plea today, it would be 6 months probation. You cannot get off early. $200 fine, a drug evaluation and any treatment, and 2 clean random screens. Probation would just call and say you have to come in here within the hour.
Was there no chance for PTI?
Apparently you have, what does the X mean? No history?
I, again, copied this literally exactly from what Ms. Mahaney said. My assistant was also out this last week, so I don't have criminal histories run on anyone outside of the clerk system. So I don't know whether or not he qualifies. I'm assuming.
Have you ever had a criminal charge before in your life?
The only other thing was when I was 16, I was arrested for petty theft, and I had teen court for it. That's the only thing.
Would he qualify?
I can't verify based solely on.
But if that were true, would he qualify?
I'm not sure, Your Honor, considering this is a meth lab that is alleged and not just paraphernalia. It seems to be more severe than just the paraphernalia charge. So with the case by
I was
case.
shocked it was a misdemeanor here with us.
Right, so using the case by case analysis, I'm not sure even if he has no criminal history, whether or not I could get a PTI approved.
Right now, that's the offer. If you want to say not guilty, you can come back and talk about the offer another time. If you want to get an attorney, you can. If you can't afford one, we can appoint the public defender.
If I say not guilty, I can come back and try to get the PTI, or just
Yes, we can talk about PTI again, but given that this is a meth lab,
it's most likely not.
most likely not.
Whatever you think's the best, if 6 months probation is what.
And there's no early term because our experience with people who are doing meth, it takes a little longer to get your attention.
Mine's right here. So 6 months probation is.
Okay, on the flip side, you make such a nice impression that I read what little I have in this report, and it's hard for me to believe that you've got a meth lab going.
It was not me. I was at the wrong place at the wrong time.
So if that's true and you had nothing to do with it, then you may want to say not guilty and talk to an attorney.
Well, then that is true, so I'll say not guilty if that's what you think is.
Well, I can't advise you, but if I was, delivering chicken soup to someone who's sick and suddenly the police burst in and arrest me because there's a meth lab going on, I'm going to say, I'm just here delivering soup. And I'm not going to take any kind of plea. But you would know better than I what you were doing there at that time. For instance, if you were there to buy some, okay, you're not making it, but you're still involved in the problem, this is probably as good a deal as you're going to get. If you were just at the wrong place at the wrong time, then I can't help you.
Right, and the paraphernalia, I mean, I don't deny that being mine, but being at the wrong place at the wrong time.
That's all you're charged with is the paraphernalia.
And that in itself, regardless of what it looks like, can be PTI.
Okay. Paraphernalia by itself is a crime.
Right.
But they have to be able to prove it's paraphernalia. Okay? This pen could be paraphernalia if somebody used it to do coke or something. So anything could be paraphernalia if it's in conjunction with an illegal substance. I don't have the list in this case. I don't know what they're charging you with. It just says paraphernalia. So, and why are they telling me all of this about the meth if it had nothing to do with you, if you had rolling papers on you? I have no idea. So, if you're going to say it's all going to come down to, yes, you had paraphernalia on you, then you may as well take the offer. If it's going to come down to, no, you didn't, then why plead to it? The defendant admitted the drug paraphernalia was his, but it doesn't tell me what it was.
Would you like to know? I don't have a problem.
I'm sorry?
I said, would you like to know?
You have a right to remain silent. Anything you say can and will be used against you, and we're being tape recorded. So
There were syringes.
Syringes. So unless you have a prescription from a medical doctor saying you have to give yourself insulin every 2 hours or whatever, then that probably wasn't allowed to be with you.
Correct.
And if you're found guilty of this paraphernalia, you can be sentenced up to a year in jail, up to a $1,000 fine. So the offer right now on the syringes is 6 months probation, no early term, $200 fine, drug evaluation, any treatment recommended. We want to find out why you have those syringes and make sure you deal with that problem.
I will take that.
Okay, makes sense to me since you've told me what the paraphernalia was. All right, we'll get you written up in just a moment. Kimberly, right to the microphone, please. Miss Wright, you've been charged with a battery. Mr. Sandor, this is Kimberly Wright. What's the state's recommendation?
Your Honor, the state is offering an adjudication of guilt with 12 months of probation with the possibility to early terminate after 6 months upon completing the women's empowerment class, 20 hours of community service, or a $200 fine, one or the other, and no violent victim contact.
But the empowerment class and the other two, or one of the other two?
One of the other two, either the community service or a fine.
All right, I'm going to have to read some of this out loud because it sounds like more like a mutual combat to me. I met with Derek Morgan. He stated that his girlfriend grabbed his hair and ripped his shirt. He stated that a verbal argument he attempted to grab her cell phone. She gave her daughter the cell phone and told him to leave. He stated he was walking in her direction and claimed that Wright just assumed that he was going to attack her. It's a good assumption. He's angry. He's walking towards her. Wright explained that the verbal argument earlier then resulted in physical contact. Wright returned Okay, it doesn't quite make sense. Wright explained that the verbal argument they had earlier that resulted in physical contact. Wright returned to the residence to collect some clothing and take her children to a hotel for the night. Morgan became aggressive and grabbed for the phone. Wright gave the phone to her daughter and told her to leave. Wright believed that Morgan was attempting to harm Miller because he suddenly changed his aggressive posture towards Miller. She stated she grabbed Morgan's shirt to prevent Morgan from harming Miller. Okay, so two versions so far say she's not guilty. During my investigation, I obtained a sworn affidavit from Morgan, who wants to prosecute. Digital photos were taken of Morgan's shirt and scratches, but the scratches appeared to be old wounds. Wright and Miller provided sworn affidavits explaining Wright's actions to prevent Morgan from harming Miller. Morgan received the victim's rights brochure. Based on the testimony provided by Morgan, I placed Wright under arrest. I don't get it.
The officers determined that she was the primary aggressor, even though there were other events that occurred. She was the primary aggressor, and we do have sworn statements from Mr. Morgan as well.
Can I see that, please? Because it's not included in this.
Oh, Your Honor, it's from his intake with our office.
All right. So I take it you're going to maintain your not guilty plea. Are you going to get a private attorney or a public defender?
Public defender.
Hey, she's talking on the phone and he tries to grab it. That's the first aggressive act, is him.
Apparently, there were things that occurred prior to that, and that's all of that is currently not discoverable.
Even in his version, he's going after the daughter to try to get the phone, and she grabs his dreadlocks to keep him from going after the daughter. Okay.
I have one question. Why they wouldn't let my daughter press charge? Because he charged after her and she's 15 years old.
Okay, Ms. Wright, at this point, it may end up being a jury call. He had no right to come after you for the phone or after her for the phone. I'm not sure if that gave you a right to pull his dreadlocks, but a jury would have to decide if that's what you needed to do to protect your daughter. So for right now, it's not guilty, and we'll appoint the public defender. You'll need to go make an appointment.